This afternoon, we could learn if prosecutors will retry Arizona rancher George Allen Kelly. There is a hearing set for 1:30 local time today. Kelly was on trial for second-degree murder for the 2023 deadly shooting of Gabriel Budamea, an unarmed migrant who was on his property near the U.S.-Mexico border. The jury in the case was unable to reach a verdict, and it prompted the judge to call a mistrial. Trial attorney Mercedes Colin is with us now. Thanks, as always, for being here. What options does the prosecution have at this point?
Good morning, Marni. Always great to be on with your show. It really will depend on the cost. The prosecutor has a lot of discretion as to whether or not they should prosecute a case. And this case was fairly costly to the state. So they'll have to determine whether that cost is sufficient to go forward. No, at the end of the day, we're talking about an individual lost their lives allegedly at the hands of this rancher. Of course, the defense have come forward. They have done everything they could to suppress some of the evidence that the law enforcement had, specifically what Kelly said when he was in custody before attorneys became involved. That was a key issue for the prosecution. They tried to get those statements in the trial. That will continue to flow into the secondary trial, where before the same judge, you'll have the same issues that will arise. And that evidence, which according to the prosecutors was incriminating because there were statements that George Kelly made while he was arrested before he was lawyered up. So it all depends on whether the prosecution, number one, decides that it's enough, they will actually have a conviction, because that's ultimately their decision. Number two, whether that evidence will be suppressed. They'll probably try to renew their applications for that evidence to come in. And third is really the cost of what this type of prosecution is. Now, in the midst of all this, we know that the Republican legislators scurried and tried to get a law together that said that ranchers like George Kelly could threaten deadly force in the event that they have trespassers on their land. That was vetoed by the governor, but you can try to see that legislation. You may actually guarantee that that legislation will resurface, because this is an issue that a lot of ranchers like George Kelly claim happens to them on a much too frequent basis.
What stood out to you about the trial itself, and were you surprised it resulted in a mistrial?
I was surprised two things, and that's such a great question. One, that the judge pretty much threw his hands up and said, okay, well, we'll just have to declare a mistrial. After a relatively short period of time, it was about 15 hours of deliberation. There was reported there was just one holdout. The rest of the jurors and the 7 jurors were actually voting to acquit. There was one holdout, at least that's reported. So it was the pressure that was obviously in that deliberation process is not a surprise for a lot of trial attorneys, but it's a surprise that you have a 7-to-1 ratio, as it's been reported, and that one person didn't change their mind. So obviously they felt very strongly about their position, and they were unwavering and unwilling to adhere to what the majority of the jurors decided that they wanted to vote on.
And in the interim, what happens at all with George Kelly? What might his defense be doing to prepare for the outcome today?
Great question. Frankly, they'll have to see 70. At this point, he's 75, going on 76 years of age. He has a family. His wife also testified. She gave some testimony about how they all felt. George Kelly has been pretty emotional about it. They've been reported about his initial conversations with law enforcement, even before the arrest, where he was shooken up and scared. And he said that he never expected this to happen, never expected, obviously, that the death of someone on his property could have taken place, that those shots were just warning shots. As a trial attorney, when you're talking to a client that may actually undergo another trial, they have to brace themselves. This secondary trial is difficult. You now have testimony from the earlier trial coming in. You have evidentiary rulings that may be overturned when the application comes again. So it's not a duplicate of the first go around. You have to prepare the client that things may change considerably the second time, and it may actually result in the conviction.
All right. Mercedes Colin, thanks for breaking it down for us, as always.
My pleasure. Thanks for having me.
Thank you for watching. Go to newsnationnow.com to find News Nation on your television provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.